o'clock, so I'll go ahead and get started. So I'm going to share my screen here. Hopefully you can all see that. Great. Okay. So today I'm going to talk a little bit about the creation of township roads. I've had a lot of questions the last couple weeks about roads and the basics of it, so I'm just going to go over creation. I was going to do extinguishment as well, but it got pretty long, so I'm just going to cover creation today. All right, so, oops, there we go. Okay. So today we're going to go over just all of the ways that townships can create roads, and those include formal establishment procedures, dedication by use, dedication by owner, dedication by plot, county road, reversion, property owner created, and common law dedication. So we're just going to walk through those and what each of those mean for townships. Just want to make sure I can see the chat here. All right. All right, so the formal establishment procedure. So there is a formal establishment procedure in Minnesota Statute 164.07 that allows a town board to acquire easements for a town road through gift, purchase, or eminent domain. This process is started by petition of about 8 landowners or by the board receiving, or it's not about it is 8 landowners, or by the board receiving elector authorization at an annual or special meeting provided in, that's Minnesota Statute 164.06 subdivision 1. So this process requires notice to the owners, a hearing, an award of damages, and the opportunity to appeal the decision. The town board ultimately decides whether or not to use this process, even when the elector authorization is sought to start the process and the public expressed its opinion about creating the town road. The discretion is still left up to the board. So if the board wants to go this route, it's important to get legal assistance, as it may result in the board taking an owner's property through eminent domain. Eminent domain is a pretty complicated process in which the government takes private property for public use with compensation. So there's a lot of steps to that and a lot of intricacies that would require kind of a case-by-case analysis done by an attorney who specializes in that field. So if you are going through the formal establishment procedure, you would want to speak with your town attorney. Eminent domain is always get legal assistance because it is pretty complicated. The next one is dedication by use. So under Minnesota Statute 160.05 sub 1, when any road or portion of a road has been used or kept in repair and worked on for at least 6 years continuously as a public highway or by a road authority, it shall be deemed and dedicated to the public by the width of its actual use and to remain that way until it's lawfully vacated. It will remain a public highway whether it's established as a public highway or not. If a road authority fails to give notice required about this maintenance, then the subdivision doesn't apply at all, though. So there is a notice requirement. This statute focuses on 4 key elements that I'm going to go through in these next 4 slides. They're colored black, so you know that we're talking about the same dedication by use route, but there are these 4 elements, and that is use by the public, maintenance, continuously over 6 years, and a notification to the landowner, which is a little bit more of a newer requirement as of 2020. So first, the first element of this dedication by use statute is use by the public. So very little use is required. The courts found that a few people using a road for seasonal access to recreational areas may be sufficient to satisfy this public use requirement. In one case, the court emphasized that the road, even if the road is just open for public use, rather than the amount of public use that occurs, that could also be used to satisfy the use element. There have been stricter interpretations of this element. One court said that 2 families using a road with no public access was insufficient. Excuse me. However, this strict analysis is rarely used, and it's more often this more broad analysis. So the next element to the use statute is maintenance by the township. So dedication by use requires a maintenance by the township, including grading, treating, brushing, weed control, snowplow, etc. You guys know all the activities that go into maintaining or improving the conditions of a town road. In order to qualify, the maintenance must be that of the quality and character performed on other public roads of the same type of road. So courts will compare maintenance of roads to maintenance of similar roads. For example, if there's a minimum maintenance road or a road that would be minimum maintenance, they'll compare it to other minimum maintenance roads within the township and how those are maintained to satisfy this maintenance requirement. The next element of this continued or maintenance use dedication by use statute is the continuous maintenance for 6 years. So the third element requires that the dedication by use statute has a maintenance that occurs continuously for at least 6 years. The maintenance does not have to be every bit of the road that is becoming a town road, and it doesn't have to be maintained every year, but the courts will look at whether the maintenance is consistent with other roads in the township. Similar to the maintenance requirement, it'll look at whether a minimum maintenance road was maintained at the same level of other minimum maintenance roads or at the same time period of other minimum maintenance roads. So it'll look at how often that road was maintained compared to other roads that are similar. To satisfy this 6-year period time mark. And then notification to the landowner. So in 2020, Minnesota passed a law requiring that before any maintenance on a private drive begins, the town must notify the landowner of any work or repair done to the road. If there is no notice, the use and maintenance does not count towards that 6-year maintenance period by the town. So before that notice, there is those 6 years that clock does not start ticking until there's notice. This only applies to roads in which maintenance began after August 1st of 2020, though. So before that, this notification requirement, those roads are not subject to that. So it's important to know when that maintenance began. In order to properly notify the landowner, the statute requires that the town will send written notice through certified mail indicating the intent to do the repairs of the road, the nature of the repairs, and the statement that's detailed more in Minnesota Statute 160.05 subdivision 1B. So all those notices must be sent to the landowner. If the landowner doesn't send notice, again, the town cannot receive the road through this use and maintenance statute. Also, the amount of the right-of-way is determined by the actual use of the right-of-way. So this can be kind of confusing, but the use and maintenance roads are established only by the width of the actual size of the use. So allowing the government units to acquire a road by use and maintenance comes from the notion that the owners will be put on notice that the public is claiming their property for a road. And the owner then has those 6 years of maintenance to dispute this public use, or they will be prohibited from challenging the public easement. The courts established that the road easement is limited to the width of the actual size of the use, which could also include the shoulders and ditches that are needed to support and maintain the traveled portion. But this can be difficult to define, and it places boards in a difficult position where they have to establish kind of the width of its roads. In order to combat this confusion, some boards respond by taking a procedure to formally acquire the 66-foot easement entirely, while others have chosen to remain with the easement through use. To help clarify, it could be a good idea for towns to keep detailed inspection and maintenance records for each road that they support, claiming that 66-foot right-of-way, and just kind of giving more detail as to what portion is maintained and inspected throughout the years. This statute is also ineffective on Torrance property. So the dedication and use statute doesn't respond to Torrance property or registered property. The property is recorded, most property is recorded by abstract. So a document describing the property is created and filed by individual. However, Torrance properties are created when a court issues a certificate of title, which contains all the records of ownership and legal status all in one document. So when that occurs, the Torrance statute states that every person receiving that certificate of title shall hold it free of all encumbrances and adverse claims. So that kind of makes this statute ineffective when it comes to Torrance property. It could be possible that the property on one side of the road center line is Torrance and the other one is recorded as abstract. If so, the town could have the right of way on only one half of the roadway, or the right of way could end at that property line. So it's important to be aware of what kind of property that road exists on before you attempt to claim it as dedication by use. Okay, now that we're through that, we'll move on to dedication by owner. So in this instance, the road is created when landowners dedicate a portion of their property to the town for road purposes under Minnesota Statute 164.15. This process requires the owner to write an application describing the land to be dedicated and the purpose of the dedication, and then the owners will file that application with the town clerk, and the clerk presents the application to the board, typically at the next board meeting, and the board may pass a resolution within 10 days accepting the dedication and declaring the land described as a town road. The damages to the owner cannot be paid in this scenario. So dedication by owner, the owner doesn't receive any damages for the dedication. And after the decision is made, the board will record the resolution with the county recorder and file the resolution with the county auditor. And then the next route to take to create a town road is a dedication by plot. So this happens when an owner develops, or a developer develops a plot that they're required to show all roads that are intended to be dedicated to the public under statutes 505.021 and 505.03. So when a plot is recorded, all lands dedicated for public use are held in trust in the town's name for the purpose indicated on the plot. So that's under Minnesota Statute 505.01. This typically means that the public road easement is conveyed to the town. However, the conveyance doesn't require acceptance by the town board, and the land dedicated for public roads automatically goes into the trust with the town's name upon filing the plot. The town board then decides whether or not it will open or maintain those plotted roads after that. The town has no maintenance obligation on these dedicated roads until the board agrees to open and maintain those town roads. And Minnesota Statute 164.11 suggests that a road dedicated by plot becomes a cartway when it's at least 30 feet wide. And if a road is treated as a cartway under this statute, the board would be prohibited from spending money on it unless they pass a resolution determining the expenses to be in a public interest. So if the developers within a plot are interested in the town taking over these roads and maintaining them, they must request it at a town meeting. When the board's reviewing these requests, they should consider the costs, the number of dwellings that would be abutting these roadways, the conditions of the roadways, and how much maintenance would be required to go into them, the degree of hardship suffered for any landowners if the township fails to maintain or decides not to maintain those roadways. And those are just a few things that the town should consider when reviewing these requests and applications. A lot of towns address these concerns with a developer before the plot is recorded in a developer's agreement, or the board has a policy already in place to work with these kinds of scenarios and developers. If an agreement is not reached beforehand, however, many boards explain that a road must be built to town specifications in order for them to maintain it going forward, just to lighten the cost on the town. So, but however, in 1977, the Supreme Court created an exception to the board's discretion on whether they want to decide to maintain a plotted road or not. And this exception was created when the court found that an impassable road complaint could be filed on a plotted road, even though the town board did not take over maintenance of the road. The county, in that case, could hold a hearing on the complaint and order the town to maintain the road anyways. So that's kind of a little niche in that, in the dedication by plot route. Next is the county road revision. So as we know, a county road can revoke a county highway, and after which it reverts to the town in which it is located. Although the statute states that the town receiving the road may vacate it, this option is often not available because there's also a statutory requirement that prohibits vacating a road if it will landlock 5 acres or more without owner consent, unless there is another access provided. So if the vacating is possible, which is rare, and it occurs within 1 year of the county revocation, the county is responsible for paying the damages associated with that vacation. However, that's rare, as I stated. To revoke a highway, a county must provide notice to the town, hold a hearing, make the repairs or improvements needed on the highway necessary to meet the county standards for a comparable road within the county, record the highway, and maintain the highway for 2 years from the effective date of revocation. And that doesn't begin until all of the other steps are followed, and that includes maintaining repairs, improvements up to other county highway standards. So those 2 years don't begin until those roads are fully improved. A property owner creation road. So town boards may open a road on land owned by the town or over the town if the town acquires an easement that allows for the creation of a road. So they can create a road on their own property. This type of road is often created when the board wants a minor change or an expansion of a road, and the landowner is kind of willing to give or sell their land to the town for its use. In that case, the board can exercise its authority to acquire property directly from the landowner and avoid using the formal road recreation process or dedication by owner process, which are a little more complicated. Towns can buy property or receive a gift. So that makes it easy for towns to kind of take on that road if this option is available. When a town has ownership of the property, it can create a road on it and allows others to use it. If a town holds an easement of the property, then it could be limited to its use and must use the property for that easement or uses that are consistent with that easement. If they don't do that and they fail to follow the conditions of the easement, that could result in loss of the easement or legal action challenging the scope of the use of the easement. So if it is an easement, you should be aware of what that easement consists of and where it is located. This process is different from the formal road establishment process that we discussed previously, because that procedure is used when the town does not own the properties it needs for the road and must take the land from landowners, which requires due process and fair compensation. It's also different from the dedication by owner process, because the dedication by owner process assumes a property is given to the town for the use of the road and sets a limit on the board's time to accept this dedication. So it is a little different from those two. Towns using this option should be aware that these roads could become use and maintenance roads after 6 years of maintenance by the public, or considered dedication to the public by common law, which is the next one we'll talk about here. Does somebody have a question? Oh, I thought I heard something, sorry. Okay, so common law dedication. This is the final way to create a township road. And a public road can be created by this common law dedication, which is typically involves an owner intending to dedicate their land to the public and acceptance of that land by the public. So intent to dedicate can be inferred from the owner's obvious indisputable conduct, and the public acceptance of the dedication can be shown simply by public use of the road. So the dedication is effective immediately upon public acceptance, and it cannot be revoked by the owner. So it binds the owner to, or it binds all future owners to this use of the property as well. Towns aren't required to maintain roads created by common law dedication unless it accepts that obligation or accepts the obligation through that 6 years of maintenance. So they aren't required to do so unless they choose to take on that maintenance of the road. All right, so that is kind of a short synopsis of the creation of township roads. If you have any questions, here's my email right there. I'll stop sharing my screen. Give you a second to take a look at it though. I didn't see anything in the chat, but if you guys have any questions, feel free to ask them now. All right, well, I hope you guys all have a wonderful week, and I will see you in a couple Tuesdays. Thank you.